Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy with a tie-in with divorce and domestic support. Joining me once again is the co-host, Jesse Barrientos. Jesse, how are you, sir?
I'm doing great, Dave. How about yourself?
I'm doing good. You're looking good,
That's
Jesse.
excellent. You too, Dave. It's always nice to see you.
There.
Yeah.
Definitely not bankrupt with that suit, that's for sure. Let's talk
a little
about
flashy
it.
there.
Things, no matter how good or bad things are in the country, I always say this, someone is hurting, someone's doing good, someone's in need of a fresh start, someone needs to reorganize and consolidate. And that's where Chapter 7 and Chapter 13 bankruptcy laws kick in to help people, those that either need a fresh start or those that need to reorganize, maybe save a home, save their car from being repossessed, keep the creditors off their back, keep the wolf who's at the door on the other side of the door.
That's true.
In your experience, what have you been seeing lately in terms of that?
Well, I mean, there are a lot of good reasons to file bankruptcy, and a lot of times things happen as a result of a tragic event. It could be the loss of a job, it could be a divorce, it could be an injury and medical bills and all that stuff. But also, unfortunately, sometimes you have folks that come in and they're repeat filers. They after 8 years and a day, they come back and here you go again, right?
Right.
And they're right back on. But we don't have debtor's prison anymore. Used to have that way back in the day, right? A different century. But it's important to give people an opportunity to get out from under and it's pressure. It's not just the finances, but it's the emotional stress of everything else. People are trying to make ends meet, and if they have a family, and maybe they're working, both of them are maybe working a couple jobs, and they have kids, and there's things going on, and they're robbing Peter to pay Paul, and they're putting balances on different credit cards, so they're trying to just save. Okay, it's interest free for 2 years, but what they don't realize is, okay, unless you pay it, then boom, all that interest that you didn't have to pay is going to show up right on that card.
Yeah, I'm glad you mentioned credit cards because the other items you said do have a factor in bankruptcy filings, but I think the number one reason that people file is they get overextended with the credit cards.
Right.
And surprisingly, when things are going bad in the country, when unemployment is high, when wages are low, when housing is down, that's when people actually don't get extensions of credit, and they can't get in as much trouble as when things are doing better in the country. So as there's more jobs, housing goes up, and the economy goes up, the lenders will actually extend the credit in greater frequency. So actually, when things get better in the country, bankruptcies go up. It's like the reverse of what people think. So right now, as things are kind of on the upswing, you're going to see an ease of credit from both credit card companies and auto lenders, and even mortgage companies are again going to start lending with greater ease. So we're going to see an increase in bankruptcies as the situation in the country improves.
Well, it just kind of in general, if you have any inclination in terms of when are the most bankruptcy filings? Are they perhaps in the beginning of the year, in January, February, right after Christmas and all this wonderful stuff, or is there another time?
No, statistically you're right. It's after the first quarter leading into the second quarter when the credit card purchases from the holiday season start to accumulate and people realize that they can't make it in January, February, and March, and then the creditors start to come out, and then right about there, end of the first quarter, beginning of the second quarter, you'll see an uptick in bankruptcy filings. And then Christmas time it slows down, the fall is slow, and summer is generally slow too. But it's that first quarter going into the second quarter is the peak.
And it just continues to happen that way. Well, let's tell our viewers at home kind of what a Chapter 7 bankruptcy is. You talked about a fresh start. So basically, as a fresh start, that means I can discharge all of my unsecured debts.
Yeah, discharge means to eliminate.
To get rid of it. However, if I have a home and I don't have a whole lot of equity in it, I could still keep the home, provided that, of course, hey, I'm up to date on my home.
Right. There's certain equity limits in a home, so you can actually file and keep your home as long as you continue to make those
Right.
payments. If you're a husband and wife filing together, you each get an exemption in the home that you can couple together, as well as other property. So a lot of people file bankruptcy, they keep their home because their home doesn't necessarily have significant equity.
And so that will allow them to be able to do that, at the same time get mostly this unsecured debt, credit card and maybe medical bills and those type of things kind of off of their shoulders. So let's kind of switch back and forth, because we wanted to talk too about the interplay with perhaps the domestic relations. But so we've talked about just basically what a Chapter 7 is. We've done the shows on that before in more detail. So what then is a Chapter 13 bankruptcy?
Chapter 13 is a reorganization or a bill consolidation. It's where a person provides all of their disposable income, whatever's available per month, to a Chapter 13 trustee over the course of 3 to 5 years, and it will pay either all the creditors back, which would be a 100% repayment plan, or more likely, a partial payment plan, anywhere from 10% on up, depending on how many creditors and who files a claim. So it's really based upon your person's assets, their income, their expenses, and of course the total debt. It's all factored together.
Well, somebody excluded from, and again, bouncing back and forth now here to Chapter 7, is my income going to exclude me from filing a Chapter 7?
It very well might. There are certain limits based on household size and based on the state you're filing in. And then if you're way over that limit, in other words, if it's determined that you have available money per month,
Right.
above and beyond your expenses, based upon IRS standards for expenses. by
Right,
the
not
way.
just something I'm going to tell you, well, I spend $5,000 in going out every month.
Right. Then the court can object to you getting a fresh start by making the argument that you have the means to pay back something to your creditors. Therefore, you would fail the means test.
Right, that's the means test to see if I'm still able to do that. Now, let me ask you this, and in a Chapter 7, if we're just talking about me and I'm married, we're not going to look at my wife's income, are we?
Oh, you are. We are going to look at your wife's income because you're a partnership.
Yeah, but
You're a marriage.
she's not filing. It's just me. I'm the bad seed, not her.
Well, for better or for worse, you're together. So if she's an earner and she has a lot of money, and she's making a lot of money, you're going to be prohibited from getting a fresh start as long as you two are together.
So I should have her take a sabbatical for 6 months?
Well, if you're divorced or if you're separated, then her income is not a factor, but I would never tell somebody to do that purposely full. That would be fraud.
So let me ask you this. If you're going to take her income into consideration, wouldn't you also take her expenses into consideration?
Yes, we will. But if she's a big earner, most likely she has a surplus. So we'll take into consideration her debt servicing, her car, her other expenses, her cell phone. But the court is going to look at the total family budget. Total income minus total expenses. And if she's carrying you and bringing in a lot of money into the household, she's going to knock you out of a Chapter 7 and force you into a 13, which effectively she's going to wind up having to pay for if you do that.
Because she has the disposable income available. Right. All right. So in the cases in which, and so that's true in so the Chapter 7, so if I don't make and we don't meet that level of income, or if we qualify for the means test, then I'd be able to do a Chapter 7 and get rid of everything else.
Well, you'd be able to get rid of everything that is dischargeable. There's a lot of non-dischargeable debt.
Let's talk about some non-dischargeable debt, too. You know what? This is my second marriage, Dave, and, the first marriage, I had to pay maintenance, formerly called alimony, and child support, and, she's just going out there buying Louis Vuitton handbags and everything else. The money's not going on the kids or anything else like that. I wanted to do an accounting, but the law doesn't provide for an accounting, and she's just tossing all that money away. I mean, I don't mind putting it in the bank account for the kids, but hey, and so I just haven't paid, and so I owe thousands and thousands of dollars, and so hey, this is great. I could do this bankruptcy, and the heck with her.
How long were you married to her?
Well, 10 years.
Okay, you stayed too long at the dance because you're on the hook now. You cannot bankrupt the child support or the maintenance or alimony payments. Those are domestic support obligations, specifically non-dischargeable. So you're going to be on the hook for those. You can get rid of the credit cards, But the amount you owe for child support and maintenance is sticking around.
Okay, well, all right. Oh, okay, that's
Told you you
interesting.
stayed too long to
Yeah,
dance.
stay too long. What if I just stayed for 5 years?
Well, it depends on what your decree says, but most
Right.
likely you wouldn't have been hurt so bad.
Right, for the maintenance formula alimony. Okay, but you still have the support, which, by the way, as a kind of a side note here, now just for our viewers kind of know at home, a little collateral thing is that obviously now since July 1st of 2017, the laws have changed, and so it's no longer a percentage of somebody's net income, of the payer's net income, the non-custodial parent, the parent who doesn't have time with the child, parenting time most of the time. It is now income shares where they take both of the parties' gross income. There's a chart put out by the Illinois Department of Health Care and Family Services, and they look at both incomes combined, they look at how many kids you have, they go to the chart, and then they determine, based upon that and how many kids, what the support's going to be. So that's just for their information. So things are a lot different now.
So now under the new law, there's actually a disincentive for one of the spouses to be employed or to be gainfully employed, because that actually reduces the amount of support, correct?
It could, but then the other factor is how much time. If somebody else has shared time, so somebody else has at least 146 overnights, that gets factored into the equation in terms of the calculation of support. And then there's a percentage. So maybe out of the total, I'm at 67%, and you're at the difference. And that also applies to if I'm paying the premiums for child support for the child, that will come out of your end too. But you could have a situation where both parties are paying, have equal parenting time, okay, so 182 and a half, I think, right, overnights, and the higher earner is still going to have to pay the other person child support, even though you have them half the time. But again, I just say
That's
this.
the child support calculation. Let's talk about the
Right.
maintenance calculation,
The maintenance calculation.
because they redid that as well.
They redid that as well, and basically they take 30% of the gross of the payor, and they subtract 20% of the gross of the payee, and that is going to represent the maintenance. And it just depends on how long you were married, and they have a chart. So if it's between 1 to 5 years, I think it's times 0.2, and if it's over.
So here we
over
go. There's
20
another
years, it's
disincentive for someone to be gainfully employed.
There is, but again, and we could, the other thing though too is that hey, you could try to depending upon the particular situation, kind of argue that hey, this person has been employed before and they have a potential to make this money, and this money should be this amount should be imputed to them. Imputed means that hey, even though they don't make it, they should be treated as if they're making that for support calculation purposes. But we talked about this with respect to we were talking about non-dischargeable debts, and again, just wanted to let the folks at home know it's a different world.
Right.
So we talk about that. So okay, all right. So my support and my maintenance, formerly alimony payments are not dischargeable. Okay, well,
They
okay,
can be reorganized, though.
they could be organized. Okay, well
Yes.
let's talk about.
A lot
Well,
of
here.
people fall behind on child support.
Well,
a lot.
let's go back and because I think there might be some other debts that I'm interested to see if they're dischargeable or not,
Shoot.
and we'll see. So, I may have gone through the IPAS a couple, 2-3 times, but
Without a transponder.
yeah, maybe. I mean, I don't know what happened.
Okay.
Maybe it fell off, or maybe it was my ex who had my car and went through it a couple, 2-3 times. Anyway, I owe $40,000.
Okay. Those debts would be non-dischargeable in a Chapter 7. However, they are being discharged in a Chapter 13. We're paying a percentage on those, and it's allowable right now.
Okay, well, let's go back. I want to explore that one. So, what about the same thing? The car, she never changed it. It's in my name. She parked it in Chicago. And, of course, when I say she parked it in Chicago, just ticket after ticket after ticket.
Parked it wherever she felt.
Exactly. And, I don't know, there might be like, $10,000 worth of, and those are fines and everything else. So what about that?
Same thing as the tollway violations. It's non-dischargeable in the Chapter 7, so it would still be due and owing. However, in a Chapter 13, you have a really good opportunity to pay back less than what's owed. So if you have $10,000 in parking tickets and it turns out you qualify for a 10% repayment plan, you'd wind up paying back 1,000 of those 10,000, and the other 9,000 would be wiped out, eliminated.
And it's allowable now. Was it allowable before?
Yes, it's allowable now as it was before. And here's the beauty too, Jesse. While you're in that repayment plan, your license will not be suspended. You will not be subject to the boot because you're in a plan to reorganize and take care of your situation. However, if you incur additional parking tickets after the case is filed, in other words, you don't change your ways, you keep doing the same thing, then you will get booted and towed, even though you're on a payment plan for the prior tickets.
Well, let me throw in a little glitch here. So let's suppose that I have an inheritance coming. And, hey, I don't want to screw up this inheritance. And so instead of taking the inheritance and doing my Chapter 7 or 13 bankruptcy, I'm just going to not want to kind of disinherit myself. But so basically just say, hey, listen, I'm not taking that money, and so it'll pass then to my children.
So you're not taking the money.
Right, but I mean, it should come to me. That's what the will says. But I'm going to refuse it.
Okay, well, I think a trustee in a Chapter 7, if you tried to make that case, could argue that you had the right to accept it, and he or she can jump into your shoes and accept it. I've never seen a case like that where someone didn't take it. Oftentimes they'll take the inheritance, they'll spend it, they won't pay off their debt.
Before they do the bankruptcy.
Right, they'll liquidate it on living expenses, maybe they can even spend extravagantly. I mean, there's really no law that says they can't do that, as long as it's not fraudulent. So obviously it depends on the amount.
Okay.
If it's $10,000, that could be liquidated relatively quickly.
Is there an exemption amount for inheritance?
No, it's just a straight $4,000
The wild card that goes
property.
anywhere. Well, what
Yeah.
about, hey, look, I have a lawsuit. I'm expecting to get like $50,000 from it.
Like an injury case where you're
Yep.
going to be the victor?
Yeah.
Okay, that would be an asset of your bankruptcy estate, but there is an exemption. There's a $15,000 personal injury exemption. And if it's workers' compensation, it's 100% exempt as long as you're not going after any kind of manufacturer of equipment.
So
If
no
it's just you
third
were hurt
party
at
kind
work.
of stuff. Okay.
Yeah. So yeah, there are exemptions, which is why a lot of people, most people in fact, go through the Chapter 7 fresh start process and they don't lose any property. They keep everything they have because they're under certain thresholds. The house doesn't have a lot of equity. The car doesn't have a lot of equity. In other words, they owe more than it's worth. The bank account doesn't have more than $2,000 to $3,000 in it, if it has anything. And all their other stuff, their 401k through work, is protected.
All of that's protected. So I shouldn't borrow from my 401k to pay my credit cards.
You should not. Definitely not. You should leave all of your money in your 401k because it's protected from your creditors. So there's no reason for you to touch it to pay the creditors.
No one can attach to that.
No one could attach to that. That's ERISA qualified. It's for retirement only. Let's put it this way. If you can't pull it out with a penalty, then the trustee and a creditor can't touch it either. So it's protected.
Okay, so that's taken care of. All right. Well, let's talk about kind of an interplay with we talked about some divorce issues in terms of maintenance and all this other stuff, and so when you file a bankruptcy, whether or not it's a Chapter 7 or Chapter 13, there's the automatic stay that comes into play.
Right.
Mostly. I mean, there are some situations where it wouldn't come into play. If I had filed and it was dismissed and I filed within a certain amount of time, then the bankruptcy stay wouldn't be in place.
Yeah, for clarification, the stay is a big stop sign that goes up that
Right.
tells creditors you can't take certain actions. Now, this also is important with divorce because if there's a divorce case pending
Right.
and a bankruptcy case is filed, the judges cannot complete the judgment in divorce without a motion allowing it in the bankruptcy court.
That's what I was going to talk to you about. Okay, so we have this automatic stay. So let's talk about pre-divorce bankruptcy filing. And let's just say that it's a Chapter 7, a fresh start, to make it clean cut, because the Chapter 13, the consolidation or partial repayment plan, is for 36 or 60-month period of time, as opposed to a Chapter 7, which can be completed within 45, 65 days, something like that.
Right.
Okay. All right. So if, hey, I know I'm going to get divorced, and there's some joint debt, and then there's some other debt and everything else. We're already separated. You know what? I get my divorce, or rather my bankruptcy, file my bankruptcy, and all my debts are discharged. Now my bankruptcy thing it's all done and everything else, and the heck with her.
Well,
All
wait
right.
a minute, you said it was joint debt.
Well, some of it, yeah. But it's all I'm not responsible for that anymore, Dave. You just I just got this bankruptcy taken care of.
Okay, but I'm just saying, if it's joint debt and you're
Right.
still married, it would make sense to file together if you're both on board with it.
Oh, she doesn't even talk to me.
To
So
wipe out the debt.
She didn't even talk to me when we were married. So no, wouldn't do that. So I guess the point I'm making is if I do that and then I file the bankruptcy, or rather I file the divorce case, right? The judge. Now we're not in a situation where we're in an automatic stay here. So that joint debt that was discharged in the bankruptcy court, the judge in the divorce court can allocate responsibility for me to pay.
Right. So you may not have walked away from all the debt.
And that's
because-
legitimate for that judge to do.
Right, because you jumped into a marital arena where the judge now could apportion marital debt. So your wife going through the divorce, she didn't file bankruptcy, so she has all this debt.
Right.
She can allege that that was for a marital purpose. She can show it was for household goods and gifts and food and clothing and mortgage payments, whatever it might be. You might actually have to pay a great portion of that debt, even though you filed for bankruptcy, which is why I was saying it'd be best if you can file together, wipe out the debt scenario.
Then that's done.
That way, when you go into the divorce arena, now it's just division of property and, child support allocation, those kind of things.
Okay, PF. Okay, so now let's talk. We touched a little bit based upon that. We talked about, all right, so now we're in the middle of a divorce. We file the divorce, and you know what? This is ridiculous. It's I'm having to pay maintenance, temporary maintenance and support, and wow, listen, hey, I work too. I need more than the 2 nickels I got left in order to feed myself here. So you know what? I'm going to file a bankruptcy. So I file my bankruptcy. So what happens?
How long are we married here?
You always ask that question. How long are we married? So let's just
Because
say
you're getting-
7 years. Lucky number 7, Dave. Lucky number 7.
Okay, once again, you stayed too long at the dance.
Oh, you're always telling me I'm staying too long. at the
Because
dance.
now you're getting hit with things that cannot be eliminated in a bankruptcy.
Yeah,
you
but
can't get rid of the child support.
but you
can't
did
get
say
rid of the maintenance.
there's an automatic stay.
There's an automatic stay
For
as
creditors.
to
Isn't she
some
a creditor?
creditors. It doesn't affect her.
But you now.
She's
So
a special class, as is the child
what happens?
or children.
What happens though to the case? The case gets stayed, doesn't it? The whole divorce case.
The divorce case gets stayed unless there's a motion to bring it forward. But the child support and the maintenance that's already ordered or not ordered can move forward because that's a special class.
So
special
right,
scenario.
because I was going to ask you that. So if I filed my bankruptcy before the hearing on the motion for temporary support,
Trick
they-
won't work.
they could still go ahead and.
Yes, the judge can still go ahead with that aspect of the divorce case. Because again, that's support for either one of the parties or the children. So that shouldn't be stayed. That should go forward, and the bankruptcy code provides for that to go forward. And you've seen that in your
Oh, yeah.
in your cases.
And in fact, we have done cases where, in fact, there was a Chapter 13 filing, and had to go in to the bankruptcy court and on a motion to lift the stay for purposes of completing the divorce.
Okay.
And that was done. I mean, hey, that's another step. Costs a little bit more money and everything else. So
And that's all filed electronically as well.
that's all filed electronically as well. So let me ask you a couple things. I think we have a little bit of time left, maybe 5 or 10
5
minutes or whatever. So we talk nowadays. We see all these things on television. I'm not going to mention them where people are invited to do things kind of like on their own. And I wanted to talk about a couple things, and then I want to get back to the bankruptcy and ask you about that. But in domestic relations, they have there's a state website where they have standardized forms, which standardized, I mean they're accepted in any place, any county in Illinois.
So like a generic fill in the blank type of
Right,
form.
and they've had forms, make no mistake, for other people to complete.
These are not for attorneys.
No.
These are
Although
for
attorneys could use it, but
Pro
they're for
se's.
well, Dave, we don't call them pro se's. Now we call them self-representing litigants. We've changed all the terms and everything, and it's no longer A removal, it's a relocation. It's no longer custody and visitation. It's the allocation of parental rights and responsibilities divided into decision-making and parenting time. So,
Okay.
but
Meet the new boss, same as the old boss.
realistically, a rose by any other name, Dave, is still a rose,
Yeah.
right? Okay. So we have all these wonderful terms. But yeah, so pro se, self-representing litigant. All right, so we've had forms in different counties, but the problem has been they haven't been consistent. And so there was this big push, and so they're standardized forms. That's a wonderful thing, you would think. And it is. For some people who don't have really any assets, they don't have any really debt or anything else, and there's no children, or sometimes with all right, that's fine. They could fill in the blanks, check off the boxes, and get their divorce, and they're done. However, this could be kind of critical for some people who don't know any better. It would sort of be like me trying to do a job that requires extensive training and just think that I can go in
Like
and
pouring concrete for your house.
pouring concrete, or maybe video and television production, or maybe it's a mechanic. I mean, if you're going to let me take apart your engine and put it back together, I know
Right.
you'd probably have a problem with that.
Yes.
I don't have any more dilithium crystals. But anyway, so that's the problem. So if you have a more complex estate, and you have retirement, and you have insurance policies, whole term, that develop that accrue value, and you have other things, it's kind of important to get an attorney to do that for you, because if you go in there and you fill things out and it's so blank and so bare bones that you're going to have a problem. And the same is true, and they do have allocation judgments for when you have children, and so it's not going to take you, I don't think, where you need to go.
Yeah.
And what's going to happen is, so that's pre-decree. So you get your divorce and all that. The problems then begin afterward. They call that post-decree, because,
Right.
well, wait a minute, I'm going to do this. Well, it's not in the agreement. Well, probably
Oh,
should
they're
have
still
been there.
calling it post-decree? I just want to make sure. Is that still
Oh, well,
there?
that's still there, Dave. Post-decree.
Okay.
After, so now you're going to have these problems. And what's going to happen is, because you didn't put the effort and the expense into it initially, you're going to pay for it, and it could be
Right.
quite costly. So with
Well,
that,
unfortunately, there's a balancing act between
Well,
access to the court
right.
and also, making it
Right.
available for everybody.
well, that's it. Is if you don't have, but so in that kind of vein, all right. So now, can somebody do their own Chapter 7 or Chapter 13?
They could, but I would never recommend it. It's just too complex. There's too many
Even if I don't have much and
potholes
there's
they
nothing
can
to
fall
do there.
into. No, it's really not something that I would recommend. The best thing to do, if you don't have a complicated
Mm-hmm.
case, is shop around a little bit, and maybe you'll find somebody that's reasonable that can help. And same thing with the divorce. If you don't have a complex case, it shouldn't be too terrible. But in Cook County, where I practice mostly, I see a lot of people that are doing pro se divorces, and they simply don't have the ability to pay for an attorney because they're already getting crushed with filing fees and appearance fees and court reporter fees that are totaling over $650 now. So it is getting outrageous.
Well,
And this is all with electronic case filing, so we need less clerks.
Well, that is what it is. But when you look at that, I mean, you could also hire an attorney to draft your documents, just that limited thing, or to review something and to make corrections. And there are all different kinds of things that you can do, but you have to, like you said, shop around. You have to ask.
Right. Great information, Jesse.
All right,
Great
Dave.
seeing you again. Thanks for
You as
joining.
well.
We'll see you next time on Legal Action. You take care. Bye-bye.